It should be going.
Okay. It's like we're recording. Today's July 28th. This is the work group for the Habeas standards, and we're going to get started. I will share my screen with the draft that we're going to be working on. Right. Can everybody see that?
Yes.
And does anybody want the font bigger?
It's okay.
Okay. Skipping the introduction a bit, I'm just going to run down my comments and questions I had while I was drafting this. If anybody has anything they want to throw out, just interrupt me and go for it. So we have, actually, I think all the questions in the table of contents get asked again and answered later on. So let's bump into the meat of the whole thing. With the first standard, the role of the attorney in habeas cases. Full disclaimer, I have never had a habeas case, so hopefully I got this somewhat near the mark.
You know, I would add a point that because habeas, when you're talking about medical habeas or mental health or, the conditions of confinement habeas cases, that a lawyer also has to work with experts, relevant experts, I think, in order to adequately present the claims and to adequately vet the claims, because that's out of the lawyer's obvious scope of knowledge. And when it comes down to habeas, what you have to present is the medical community standard of care, or the mental health community standard of care, or the segregation in corrections standard of care. You have to work with experts to be able to present that. And if you don't work with experts early on in the case, as early on in the case as possible, you're going to miss claims. And that you're just going to miss claims.
Okay.
For even, putting together the components of a replication. I work with experts who give me their opinions with, doing the best we can with what we have at the initial stages of the case, because you usually don't have a lot of discovery, but they can still interview the client and get the client's report on the conditions issues and help me analyze what is and isn't, a potential claim as a medical issue, et cetera.
So we do have a whole section on experts.
Yeah.
But I'll tack in to the role of the attorney that they need to be able to abide by this. Does this look like kind of what you're talking about?
Yes. I think I would just make it even more prominent in the role of attorney in habeas cases. I see a lot of cases where people haven't gotten experts, and cases are very disadvantaged by that and can go on for a very long time without one, and they're vulnerable. So I would put that, just like, make it as prominent as possible. Maybe in the bullet point, a lawyer should exercise reasonable professional judgment, and obtain expert consultation and assistance when outside the lawyer's, scope of expertise.
Say that one more time, please.
Something like a lawyer, the bullet point, a lawyer should be familiar with. No, I'm sorry. I'm in the number one, role of attorney.
It's right here. Yes.
Yeah.
On page 3. Let's see. Find it. Okay. On the next to the last bullet point,
Mhm.
I would add something like a lawyer should exercise reasonable professional judgment regarding yabba, yabba, yabba. Consult with the client on the strategy to achieve the client's objectives, and consult experts as necessary.
Okay. We can clean that up.
You may want to just preface that bullet point with like in conditions of confinement cases.
Yeah, right. In conditions of confinement cases.
Oh, and I don't know that I've given my my spiel on disliking typing in front of people, but please forgive any spelling and grammar mistakes that pop up. We'll fix them in post.
Yes.
Yeah.
Understood.
Okay. And I'm going to tag this whole thing work group to stress the importance of and need for experts. Just so we know that we're doing this on
Mhm.
purpose and it's not duplicating stuff down below.
Yeah, great.
Okay. While we're on this one, do pro se people ever do habeas cases with attorney advisors? I know in the criminal context it pops up sometimes that a judge will say you're appointed in an advisory capacity to this guy who wants to go pro se, but I don't know if that ever happens in habeas contexts.
It can. I've never had it happen.
Okay.
I saw it happen once, sort of, in a like extradition habeas where the client added in some pro se conditions of confinement
Mhm.
claims, and they were kind of being litigated in parallel. It did not work well. So I think, yeah, so I think that that can be relevant, although rare.
Okay. So we will leave the section in. Um,
Can I add one thing?
of course.
I think saying it's a pro se criminally accused person, that is
Oh,
maybe
yeah.
not the
Oh
language to
yeah, that's
use in a
probably not.
habeas.
Litigant?
Or plaintiff.
Yeah, plaintiff, litigant.
Yeah, I think we use plaintiff throughout, so we'll just keep
Yeah.
that
That's good.
language. Good catch. Thank you.
And you probably want to change reference to defense counsel and criminal proceedings at the bottom of that one too.
Yeah, I probably
Same.
do.
And accused and all that.
Two. There we go. All right. Anything else we want to add into or highlight in the role of habeas counsels?
See anything off the top?
Yeah.
Looks good.
Great. All right. The education and training section. So this is pulled from the criminal standards that they have to complete an average of 10 hours of CLEs each year in criminal cases. I don't know
This
if that is.
It's not available.
Yeah.
I wish it were. It's
Okay.
just there is no habeas training. There's nothing almost.
Yeah.
I mean, I think you can't I think actually what would be more useful, because there is no
Mhm.
habeas training, is to say civil litigation training in the rules of evidence, particularly because that is going to be that's really going to be the heart of a lot of what folks do. So, given that there are trainings in that area,
Okay.
lots of them, and civil rights and prisoners' rights,
Mhm.
like OTLA, those that should be kind of the domain of training directive.
And is 10 hours reasonable to expect in a year?
Seems like it. As long as there's like some to choose from, you know.
Mhm.
Right.
So that's spelling thing. Second word. Thank you.
Criminal law is just not even relevant, strangely, uh, for the most part. I mean, all they need to know is how to read a charging sheet.
I would say that's a little bit different for the authority for confinement cases, and like extradition habeas,
Hmm.
um, where where like criminal law
Mhm.
Right.
would be what you
That's
need,
true.
like sentencing.
Hmm.
Extradition is, I mean, you're not going to find CLEs on extradition, I don't think.
Right.
Maybe there's one somewhere, but that's
Okay.
probably more, I mean, yeah, I think like sentencing stuff would be helpful, I guess. And
Hmm.
then criminal law general, I don't know. I don't know that there's anything more than what a criminal attorney would normally have. Um, and I think a lot of that, like what you need to know for that is familiarizing yourself with the law and the cases. Um, that's where you're going to get the
How about
information.
that? It's just a catch-all. Lawyers practicing the authority to confine habeas cases may supplement this requirement with relevant criminal law CLEs.
I would make it more specific because that's just so broad. People
Okay.
won't know what to look for. I would say like something like Meg just said, it's specific to sentencing is going to, I think that is probably the most relevant area.
Yeah.
Okay. Sentencing, extradition. Sorry, Meg, what were the others?
I don't think I have others.
Oh, okay.
Okay. Yeah.
Okay. Almost that. Bumping back up to the top. Anything else we need in the education training section?
Um, yes. I think it's too much to ask to be aware of Section 1983 and federal habeas relief requirements because they're so different
Mm-hmm.
than what you're going to see, and they're so complex than what you're going to see in state court. The only, like, I'm talking about conditions of confinement. That's kind of my bread and butter. I would, um, I would put in specific cases that they should be aware of, um, and should have a real handle on. And I would keep that to state cases and then a couple key cases like Estelle and uh, a couple other cases that are like key Eighth Amendment cases, because we do raise Eighth Amendment claims, federal and then state, and then unnecessary rigor claims under the state constitution. So that section I'd be happy to work on, to come up with some
Sure.
with anybody else, some specific, and there's also like section 1983 is just, it's so gnarly. And it's going to be like, there's also, it's much less favorable to our clients.
Mhm.
I think when
So,
we had talked about that before, I'm not sure if this is in there from our previous discussions, but I think we talked about this. It was about just being aware of any like potential ramifications like the habeas case could have for
mm,
future federal cases. Um, is that
hmm.
something I'm not entirely sure what those are. Um, but I
I
know there
just,
can be like some race judicata stuff.
I just think that's too much. And
Okay.
I always tell people like, I don't know about your 1983. I'm not going to answer any questions about that because that's getting outside the purview of my representation. Um, and then, you know,
Mhm.
it, the only way it comes up in my cases is if they win their case, we're going to do a 1983 because they're in such a great spot, on the Eighth Amendment claims, especially. But I think because clients will ask constantly about their 1983 options, and we just shouldn't even
Mhm.
like, it should just close it down because it's too gnarly, it's too complex, it's outside the scope of representation. Um, you
So
can just
maybe
know,
Maybe that's
yeah.
what I should say then.
maybe what we can do is bump this down to one of the bullet points and write it like we write in the other context that lawyers should be aware of habeas, the potential for habeas relief.
You mean in states?
So instead of like the lawyer should be aware of the availability of Section 1983 suits, just, well,
What I would, for
yeah.
my, for me, what I'm concerned about first is, are you making a record for appeal?
Hmm.
State appeal. That's my concern. Are you making a record that is sufficient for state appeal? And then secondarily, the only thing I tell people generally is, there are statutory requirements for when you need to file, and you generally can't file the same claims when they're pending in the state case. But, um, it needs to be exhausted. But even that is kind of getting a little farther than I'm comfortable with. Others may feel differently. I just really shut that down because then suddenly they're like in court filing a 1983 saying, I have an attorney. It's Tara Harrible, you know, and she
Yeah.
advised
Yeah.
me on all this stuff. And
And
Yeah.
that's not what you want.
right.
No.
Um, let me think about this. And
I mean, there's
Tara,
a
that
way to
list
do
of
this.
cases might be helpful.
Sorry. Just like the way my office handles like federal habeas and after like post conviction is done and you can move on to federal habeas.
Hmm.
We basically inform them that that is a right that they have, that they can do that the federal public defenders will help them with that. And they should be aware of like the timeline, and the statute of limitations. And that's kind of the extent of it. Like we make sure they know about it and that they have to exhaust their remedies in state court, like those kind of basic stuff that we have to
Hmm.
do, or that they have to do in state court to get to federal, and who to contact with questions. And obviously that's going to be, you don't get appointed counsel in 1983 the same way. But I wonder if just something like that would be
Yeah,
helpful, just sort of a like
Yeah.
inform, or let them know
totally.
that you don't know the other
Right.
the answers,
Yeah.
but then to
Yeah.
extent.
I think something
That's,
like that would be
yeah,
better.
just a blurb that you
Yeah, right. Just like a
never
paragraph.
stray from,
Right.
unless you are representing them on the 1983.
Yeah.
Mhm. Okay.
And you do that sometimes, Tara. Is that true?
Yes, yes.
Cool.
All right. Let me think about how to word that. I'll, if you guys have suggestions, please email me and we'll pick that up next time.
Sounds good.
Anything else in this section?
There's you have another highlighted part, right? For the
Oh
juvenile?
yeah,
Or
I
no?
guess I do. Yeah. Um, a couple. This seemed like just being aware
Yeah.
of services seemed like a useful thing to leave in.
They're in custody. I actually have a few things for this section. That in particular, I mean, I think it's asking more than the scope of representation for a habeas. They're in custody.
Okay.
Everything that is involved is going to be either, you know, available in custody or referred to an outside provider, at least for the conditions, which is what this section
Hmm.
seems to go to. Um, if it becomes relevant to talk to a client about, if they're going to be released during the course of your representation, great, you have that conversation, you look up those things, but it's not like something that is going to be that relevant for the vast majority of your representation in habeas.
Yeah, it seems like the unusual case where that would be relevant
Okay.
rather than
So we'll
oh,
pull that. And then the juvenile uh, questions.
Yeah.
Are there juvenile habeas cases?
This is really, I want there to be. It's an area that really needs representation. Um, they hardly ever come because there's not access to the forums. There's not, you know, youth, juvenile prison lawyers. So they just don't know
Mhm.
about it. It could be, it should be, it could be very powerful. Look at what's happening in OIA now. Um, but yes, so it's the short answer is there can be, but there really aren't, to my knowledge, many cases being raised. But um, I think having something that addresses the fact that it is, even if it's not very accessible, it's a right, is a good idea.
Mhm. So I don't know
But
how. Oh, go ahead.
yeah, this section addresses again the criminal kind of context.
Yeah,
Um,
this was pulled verbatim from the criminal
right.
standards, just to remind me that I need to ask about juvenile standards and habeas.
They're the same, except that, I mean, in theory, but I think, being sensitive, to the level of trauma, but there's trauma in the prison population, adult prison population. But I think making some comment about the sensitivity to trauma within the population, and, looking for resources for that is a good idea.
Okay, I'm gonna call that a placeholder on that language.
And just going back up in this section, and I'm sorry, I'm just jumping
Great,
in like
do it.
totally, without context of work that's been done. And I don't mean to like step on anybody's toes. I'm just kind of giving feedback as I see it. Um,
Do it.
okay, so I, for this section, the first bullet point, in order to remain proficient in the law, um, I don't think Oregon State Legislature, federal, I mean, Oregon state legislature is not really going to be relevant.
Mhm.
Federal appellate courts aren't really working through these, but the state appellate courts sure are. And so that's where the focus should be, I think.
Okay.
The
Appellate
second,
courts. Hold on. Do we want to change, we should probably change this to habeas, or do we want to change it to civil?
habeas, I think.
Okay.
And civil, well,
Court rules and practices applicable to habeas and similar civil cases.
I mean, there just aren't similar though. I
Oh.
think just saying habeas, I don't know,
Okay.
Meg, what do you think?
Are the, yeah. Yeah, are there civil cases that would be used, like medical malpractice cases? Would those ever have anything important or helpful? I mean, I
No,
know it's
because
standard, just
you
like,
don't, yeah.
yeah, it doesn't really seem like it.
The only time I use civil case law that is not habeas specific is for like attorney fees or occasional other motions practice. But that's
Mhm.
just really specific to whatever the motion is. Um, I think it's just fine the way it is.
Okay.
Yeah. Um,
What next?
let's see. The next button, maintain membership state. This is again, this is like focused on criminal law, so it should probably be revised.
Mhm.
There are not like there isn't a habeas listserv that I'm aware of. So
Mhm.
the closest thing to kind of send people in the right direction would be a prisoner's rights listserv. Those are always closed. So, they're going to have to seek those out and find a way to get, an invitation.
Okay.
But there are prisoners' rights listservs all over. And,
Yeah.
these issues will come up in a broad way.
Okay.
The next one, about co-counsel.
Mhm.
Is OPDS willing to make a commitment to people who don't have experience in habeas to provide them with, um, paid co-counsel relationships for training? Because that's the only way they're going to get that.
Yeah, and I don't know the answer to that. And I don't think, well, frankly, I don't think I'm going to be the person to empowered to make that commitment. The question I think for the work group is, do we think that is something that would be considered a best practice?
Yes. Oh my
Okay.
God, yes.
Yeah.
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 That's actually the most important thing
Yeah.
is that people are coming in, getting contracts, they have no training, no idea what to do, and it's a very
Okay.
rarefied practice area. So I think that's actually the most important thing is getting people connected with real resources for training and
Yeah.
mentoring.
I feel
Okay
like the
then.
people that have newly entered into like habeas representation,
Mhm.
there have been a few from like the medical malpractice world, like maybe just two. And it seems like they've done pretty well of like figuring out how to, because they're familiar with the issues and how to work with experts and all of that. So like that
Mhm.
has worked pretty well. But I feel like criminal attorneys coming in to habeas without any of that, like those don't go super well.
Okay. So then
There's
I
just,
think for
and there's like no training, right? We don't have any training for them anyway. There's no other way to get training on their own, like they, even if they wanted it,
Yeah.
there's
yeah.
no resources. So
So then I think for our purposes for the work group, we leave this in as a best practice standard, and we can, change the wording around as we need to. If somebody later down the pipeline, as this gets reviewed by the OPDC executive committees and commission, if they decide they need to take that out, they can do that. But if it's what the work group feels is the best practice, then I'm content to leave it in
Cool. Yeah.
for our work group recommendations.
Great.
Is this language good, or do we need to change that?
I think it is a good summation of what's needed.
Yeah.
Okay. All right. Anything else on any of these bullets?
In the next one, is there anything
yeah.
else you would add, Tara? I don't know, like.
This comes with training. And I think that the way it's written, the expectation is really big.
Mhm.
I don't think that people should be expected to know what private medical treatment and facilities and programs are necessarily. I mean, that's too broad. The DHS, I don't have cases that involve issues with DHS and habeas ever, so I don't think
Mhm.
that needs to be in there.
Yeah.
Okay.
Local community corrections programs. Again, that's kind of the same thing as knowing what the local resources are. It's just not relevant to
Mhm.
habeas. I would say the ODOC policies in the
I guess those could be
OARs.
relevant for jail cases just before you take it out.
Oh.
Jail habeas, right? Is that what it's getting at? Local community corrections?
I think
I don't
so.
know. Okay. Yeah. Just because there are
Yeah.
both.
I mean, that's like saying no the prisons, though.
Mm.
Yeah.
It's really broad, and
Right.
you want to give
So
people
these
stuff they can do.
in the bullet points are designed to be somewhat broader aspirational goals for us, and then the non-bullet points are kind of the black letter what everyone has to do to be kind of minimally
Those seem like
competent for it.
like
So they are broad, but
yeah.
somewhat by design.
Those seem like areas that you will need, like areas you will need to familiarize yourself with depending on the case and like the
Mhm.
specific parts that are relevant to your case. But I don't know that there are things you need to, right, I think to Tara's, but like it's not stuff you need to come into a case knowing all of this. These are like areas you will need to research or like things you will need to research. I mean, they're departments, I guess. I don't.
Well, understanding that then, I'd still say the Department of Human Services should come out. It's just not, I can't see any
Okay.
way that that's relevant to habeas. And then the rest of it, is kind of case by case basis, but, makes sense if it's kind of a broad suggestion.
Yeah. And then we've tacked in or should know how to familiarize themselves as needed for their cases. So that the idea being to cover, I don't know this stuff, but I don't get it a lot, but I know where to find it when I need it. Situations, if that makes sense.
Again, this is not relevant because if they're unhoused, they're out of custody and then their case is mooted.
Mhm.
Tara and Jordan, from the juvenile side, since I know that we're considering potentially that, it makes sense to say the juvenile department instead of the Department of Human Services, simply because juvenile department are the ones who run the detention facilities,
Oh, yeah.
and possibly the Oregon Youth Authority.
Yeah. That makes sense.
What is it,
Who's
Kevin? The Oregon Juvenile
Yeah.
Department?
Oregon Youth Authority would be the statewide agency, and then the local juvenile department would be the equivalent to local community corrections programs.
Okay. And then where did you see something? Was there something about unhoused in this?
Mhm.
I think that was the bullet point where I took out.
Oh, okay. Yeah,
Did we do? We did.
I think we took that out.
Okay.
Yep. Okay. Next section.
Oh, let's see. Which one?
Are we ready to move on to the workload section?
Oh, yeah.
Okay. This is similar to what I think is going in all of the standards. Don't accept cases beyond your ability to manage the workload. But if there's anything anybody thinks need to be put in or taken out.
I think, let's see. I would add, because there's a special statutory right to an immediate judicial scrutiny of a
Mhm.
habeas case that isn't, I think, litigated enough and is a great tool. That under those bullet points for right to an expedited hearing, et cetera, to really just pinpoint the right to an immediate judicial scrutiny of the case, including docketing of hearings and trial dates. And I'll give you the site for the statute. ORS 34.362. I would take out the right to file challenges to the evidence because that's a criminal.
Oh, hold on one second.
Oh, yeah.
Right to an expedited hearing. Evaluating. All right. Lawyers should be cognizant of RS 34362, the right to an expedited hearing when evaluating their ability to accept representation in a case. That highlight it.
That seems good.
Yes, I would put
Okay.
after expedited hearing a parenthetical with the quote so they can find this in that statute because it's called immediate judicial scrutiny.
I can look that up and paste it in.
Well,
You guys don't need to watch me pull up statutes.
okay.
Okay.
How does
So what was the next point you wanted to, something about
on the
filing?
on the next page is standard 2. What is, I'm confused about what's happening between 3 and then standard 2, then the next page. No, the other direction.
Yeah, I was trying to figure out what I was doing. So it
that's
was,
different.
we
I
had,
see.
so I had them broken down into standard 1 point. So this would be 1.3.
Okay.
And one of the things I'll do before our next meeting is clean up how this actually reads. So the
Okay. So
references will be
standard
a
2 is
little
like
easier.
another big section. It's not a subsection under 3.
Right.
Got it. Okay. Thank you. Sorry.
Right.
Carry on.
Okay. So Tara, you were saying something about the requirement of filing motions.
Let's see here. Right to file challenges to the evidence is not something that a habeas plaintiff's counsel would do.
I
Okay.
think that on the next page, Jordan.
Okay, good. So before we dive into this, I suspect this is going to be a longer discussion than the about 10 minutes we have left in the scheduled time. We can dive in and get as far as we can in 10 minutes. We can keep this discussion till next time, or we can go longer than 2 o'clock, but I want to be cognizant of time and everybody's schedules.
I can't go longer today. I'm on a deadline, but
Okay.
I'll do, whatever you want to do.
Okay. Meg, do you have a preference?
I mean, I'm fine starting if that doesn't seem like a waste of time.
I don't know that it's a waste of time, but I think my preference, if you are both okay with it, would be to break here. We can go back over the changes between now and next time, and then dive into this when we can get through the whole section of it.
Can I just say a couple words about it now,
Yes.
though? Because I don't think it's actually a big discussion.
Okay.
There are two there's really, you can file a motion for summary judgment, which is equivalent to a motion for dismissal on
Mhm.
either side. And otherwise, motions practice is not allowed in habeas.
Oh,
That's in the habeas statutes. There are going to be motions for like change of, your basic boilerplate motions, but like,
mhm.
the evidence is never something that the defendant presents necessarily. That might, in this context, this is about a criminal context, is what I see.
Mhm.
The kind of motions that might happen would be like a motion in limine or, those kind of basic trial motions, but like, just to put that kind of outline around it, that there's a particular, there's a statutory requirement that limits motions in habeas, and that's because it's supposed to have an immediate, immediate judicial scrutiny and not get bogged down for 5 years in stupid motions.
Okay. I will make a note to pull that out and we can talk more about that next time. Okay.
Okay, great.
All righty. Any last words anybody wants before we cut the recording?
I think so.
Great. Well, I just want to say thank you both very much for your help in this. You are 100% correct when you say this is pulled from a criminal background, because my background is criminal and I pulled it from the only place I know. So you guys and the help you're providing with this is absolutely essential to getting anything even, workable. And I think we're going to come out with something way better than workable. But I wanted to say thank you for taking the time and for the help with this project.
Well, thanks to all of you too. It's
Yeah.
very important. This is great.
Agreed. And with that, Kevin, I think you can stop the recording.
The only way I know how to do that is to kick everyone out of the room. So
Okay.
have a great afternoon, everybody.
Until next time
Bye.
then.
All right.